Greetings. My name is Jennifer Koh, and I'm a law professor in the United States. Over the past several years, my research has focused in part on a phenomenon in U.S. deportation law that I call shadow removals, the use of deportation procedures that bypass U.S. immigration courts and immigration judges and instead empower frontline deportation officers to directly issue removal orders with very little process and yet with maximum speed. And so in this video, I briefly describe the landscape in which shadow removals take place, highlight longstanding critiques, and leave viewers with resources for further learning. I'm recording this in late November 2020, a few weeks after Election Day in the US and about 8 months into the COVID-19 pandemic, which seems important to mention given how quickly the landscape here is shifting. But by way of background, the conventional wisdom around U.S. immigration law is that orders of removal are adjudicated by immigration judges presiding over immigration courts. And indeed, the U.S. immigration courts are an important part of that system, and there's a great deal of literature on dysfunction in those courts. And so while shadow removals are aimed at shifting attention away from the immigration courts by way of context and background, it seems important to mention them a little bit. The American Bar Association Commission on Immigration stated in a 2019 report that the U.S. immigration courts are irredeemably dysfunctional and on the brink of collapse. And some of the critiques of the U.S. immigration courts have included basic structural features of the system, such as the fact that the immigration courts, despite the name, are not actually part of the American judicial branch of government. Instead, they're part of the executive branch, specifically the Department of Justice. And immigration judges are supervised by the Attorney General, who serves at the pleasure of the U.S. President. The U.S. system of immigration detention also imposes serious fairness concerns on respondents' ability to navigate defenses to deportation, as well as carries other high human costs. Over 20 years ago, U.S. scholars commented on the exercise of discretion in the immigration court system and compared the process of seeking asylum before the immigration courts to the gambling game of roulette, because one's likelihood of success depends most on the judge to which one is arbitrarily assigned. Under the Trump administration, pressure on immigration judges to process claims faster have led to bureaucratic developments like the speedometer-like case completion goals that appear on every immigration judge's computer screen, as well as other ways in which immigration judges have lost the ability to manage their caseloads. Yet still, the fundamental reality is that formal orders of removal most formal orders of removal in the U.S. system are actually not processed by immigration courts at all, but through summary removal procedures that bypass those immigration courts. And so, in fact, two of the processes which are listed on the screen, expedited removal and reinstatement of removal, account for over 80% of all formal orders of removal. Those procedures were first authorized by Congress long before the onset of the Trump administration. They've been expanded over time and to various degrees by various administrations under Bush, under Obama, and also under Trump. I'll very briefly explain each, recognizing that they all trigger their own regulatory schemes, which also involve limited defenses and some unique procedures. And I'll mention a few other things, which is that using these procedures, again, enables the government to deport people quickly. Some take a matter of minutes to process. They often take place from the context of detention centers. Lawyers, even government lawyers, are typically not involved. And so what we have is a system in which frontline agency officials are acting as police, prosecutor, and judge. So first off, expedited removal. Expedited removal has historically taken place at the border. Now, how the border is defined has expanded over time. But again, expedited removal has been used most prominently on asylum seekers who lack entry documents. The Trump administration in particular has expanded its use of expedited removal, for instance, by attempting to issue a rule that would have allowed Department of Homeland Security officers to use it against any person present in the U.S. who could not prove that they had been here for the prior 2 years. Now, whether that rule is actually implemented, in particular under the Biden administration, is yet to be seen. Second, reinstatement of removal can be used to summarily deport people in the U.S. who were previously deported through a formal order of removal, no matter how long they've been in the United States since, and that includes cases where the first order of removal was an expedited removal order. And then third, administrative removal, while less common, also deploys similar summary removal procedures on non-citizens who do not have the status of lawful permanent residents, also more informally known as having a green card, and who the government believes has a prior conviction that falls within the aggravated felony definition in U.S. immigration law. There are a number of critiques to be made, in particular around due process. While expedited removal, reinstatement, and administrative removal allow for limited defenses based on fear and possible persecution, other immigration law defenses to deportation are restricted and often not available. Expedited removal in particular imposes harsh restrictions on judicial review and access to the writ of habeas corpus before the U.S. federal courts. There is no right to government-appointed counsel throughout the immigration system, but the detention aspect plus the speed involved with these procedures makes access to counsel particularly difficult. The detention element also brings a coercive dimension to these procedures, and multiple shadow removals can be layered atop each other to subject people repeatedly to deportation and detention without ever appearing before an immigration courts, thereby creating legal sites that I have analogized to legal black holes. So for further reading, here is a list of pieces that I've written that further explore the subject of shadow removals in more detail. I hope this video has been helpful to viewers, and thanks for the opportunity to share my research.